Dear students, GPS CLAT Academy at Gyanodaya, a senior secondary school at Sikar, supports its students in their CLAT preparation. We have started a lecture series which will be delivered to you on a daily basis on YouTube. The lecture series revolves around discussion of mock papers. You can request us for the concerned mock papers. If you intend to join us in our daily discussions, you are most welcome.
Double A MCO.
Go, go!
Nationwide is on your side.
So that gives you an idea. When the sound comes, particular sound comes, then that will tell you which company is this. You must have heard the ringtones of various phones, and if you have had a specific kind of song, it will have a peculiar ringtone which will be dedicated to trademarks. You must have heard on the television Nirma advertisements when the girl is dancing or gyrating, and then do the Haseen Safedi, Nirma Silai, that kind of, the same tone, the same music, the same audio set, the same visual effects, same are repeated over and over again, over and over again, over and over again. And what is the objective of this? The objective is the tunes get memorized in the minds of people, just like they have got memorized in my mind, right? They automatically help in identifying in the store when you visit. Then that tune at the back of your mind will be bringing you the image of the girl who is gyrating, who is dancing in circles, and you have a liking for the brand when you see the brand's products actually in the storeroom. That is the task of a trademark. What is the task of a trademark is that it will help in distinguishing the goods of one company from the goods of another company. This is a part of the promotional measures that are undertaken by countries, by companies, um, in order to promote their goods, in order to distinguish their goods from the goods of rival companies. When a specific trademark, when the tune comes in, then you know that we are watching a video which is of Century Fox studio, because that or of some other studio. When we are watching an advertisement, then these are all trademarks in action, right? And what exactly is a trademark? It is a sort of intellectual property, right? It is an intellectual property which a company uses in order to distinguish their goods from the goods of competing firms, and it has certain business value. What is the business value that it has? The business value inheres in the goodwill that it acquires in the market, the perception that it has of the customers, the importance that the customers assign to the goods of the company. These are all captured in a trademark. The goodwill for the products, the perception for the company, the the kind of the kind of merchandise that the company sells. Everything gets encapsulated in the trademark. So this is an intellectual property, of very valuable intellectual property, because when there are so many competing firms and all the firms are selling more or less the same products, or even if they are selling different products, I mean, the firms which are selling the same products, how do they distinguish themselves in the market? The only way to distinguish themselves in the market is through the means of a trademark. And therefore, trademark is a valuable right, intellectual property right, which is which has very great economic significance for the company. And the trademark cannot be, descriptions cannot be trademark. For example, if a tube light is there, suppose a tube light, or say a fan, or suppose any product which is there. You just can't uh, you just can't register something like with a fan. You can't say great air. You can't say that. Environmentally sound products. Trademarks should not make any sense. They should be combination of signs or names or devices or whatever, but they should not make any sense, right? The moment you use an ordinary word as a trademark, it will not get registered because that is you can't use the ordinary words as trademark. You can't register basmati as a trademark because basmati is a particular kind of rice which is found in North India, and it is known for its aromatic quality. So basmati cannot be used as a trademark. Basmati is more of a geographic mark rather than a trademark. Geographic mark is also in a way a trademark only. But then, for example, if your company produces goods which are very technically sound, then you can't register something like top engineering marvel. Like that, you can't register these words because these are ordinary words. But you can register something like something which is senseless. That you can do. For example, you can write, you can register Zomato, you can register Swiggy. Now these don't make any sense. These are senseless words. For example, uh, so now this is what is a trademark. Then there are certain specific things about a trademark, and that is it is registered for a particular duration of time. It is not forever. It is registered for 10 years. This is what this thing provides. Then the property that inheres in a trademark is basically the right to use the mark and the right to prevent others. So, in other words, that is to say, the property that is given by the mark is the right to use, or right, or should I say, the right to exclusive use, not non-exclusive use, the right to exclusive use. And you can also give a franchisee of your trademark, and you may be entitled to certain royalty payments also for the franchisee. And then the registration of the trademark basically is granted only when you have in existence data which shows that the trademark has has been actually used by the company over a long period of time. And goods, the use of goods, the marketing of goods, the promotion of goods, company's goods is associated with the logo or the design that is there in the trademark. So that is required. That you'll have to prove when you go for registration of a trademark. Then earlier the law was that the trademark should be capable of being graphically represented. That means in head you should be able to write it. But now this has been changed, and now the trademark can inhere in the sounds also, smells, fragrances also, in the symbols and the colors, shades. All this is also a subject matter of trademark these days. Earlier, it was not like that. Recently, there was an amendment in the law, and these have also been forbidden. Then there are collective marks which are provided in the rural areas, and where suppose cooperative is working, and then they have certain goods which are being produced. So instead of having a mark which adheres in one company, there can be a number of companies which share the shared trademark. So this becomes a collective mark. So I hope the trademark concept is clear to you. Will not inhere if there has been no prior user. If there is a prior user over a long period of time in the association with the company's goods, you can go ahead and register the trademark. Registration can be done either nationally. You can opt for national registration. That is to say, the protection will be of national level. Registration can be done internationally in several jurisdictions. Suppose there is evidence of use of your trademark in several territories, several jurisdictions across borders of several countries. Then you can register your trademark in several countries. Either you can do the registrations piecemeal, or you can go through the World Intellectual Property Organization, WIPO, which is based in Geneva, Switzerland, and the Madrid system they call it. And once you file as an application there, then you become eligible for trademark protection in 130 countries. So if you have an international trademark, then you can use the WIPO system. WIPO, incidentally, is a specialized agency of the United Nations, and a specialized agency just like the WHO, which is an independent and specialized agency of the United Nations. So that way, the WIPO is also a specialized agency of the United Nations. For example, Food and Agriculture Organization is a specialized agency. For example, International Labour Organization is a specialized agency of the WTO. For example, IMF is a specialized agency of the WTO. So these are independent organizations which work within the UNO framework, not the WTO. Sorry, they work in the UNO framework, not in the WTO. WTO is independent organization. WTO has not been kept in the United Nations framework. So this is what is trademark, and trademark, as I have said, the trademark. If you don't use the trademark, if some other person starts using the trademark, then the protection can be lost. Also, the protection is granted only for a particular period of time. After the expiry of that time period, you have to either renew the trademark, uh, or you may give up the trademark if it is no longer in use. So you have to demonstrate the use of the trademark that customers associate the the use of the trademark with the particular goods and services, goods commodities that are provided in the district. So and the trademark is different from any other property mark. There, apart from trademark, there can be other property marks also. Property marks like you don't register the trademark. So if you don't register the trademark, what will happen if you don't register the trademark? If you don't register the trademark, then but you are using the mark, say over a period of time, then there can be a common law suit to prevent the infringement of your mark. But then you will have to prove that the suit was in use with respect to the goods of your company. And in order to claim the protection, you'll have to prove your prior user. But in case of a registered trademark, you have to prove nothing. You just have to show that this is our registered trademark, and you don't have to show that we have been using it. You just have to show that this is our registered trademark, and the other rival firm has started using the trademark for the purposes of promoting their own business. So you can have an injunction or a stay order or an interim relief against such unauthorized use of the trademark. So I hope this is clear. Businesses often use similar trademarks. For example, if you have the trademark something like Amul, then somebody will register the trademark Anul. Why? Because it is very difficult to difficult to acquire that foothold in the market, and that is why trademarks become important because they identify. So if you are using Anul instead of Amul, then they are very closely related to each other. So this is going to create a confusion in the minds of the buyers. The minds of buyers may be led into believing that Anul and Amul are the same thing. What is the difference between the two? So the products of Anul will be getting the advantage out of the association that Amul has with the products. So the goodwill transfer case will be made out, and that would be a ground for interim relief against Amul, because that would be a dishonest use of Amul's trademark. So an infringement suit, a stay order would be there to prevent this thing, and there can be a suit for damages also for the damages that have been incurred by the company which has the trademark Amul. Uh, I hope this is clear to you. So after having said that, I can go to the questions. Uh, Renowned fashion brand. This is the first question that I'm taking up. Stylify successfully registers its trademark for its logo under national trademark law. Company then licenses the logo to a startup boutique fashion nest for a hefty annual fee. A competing fashion house Trend Run starts using a logo that closely resembles Stylify's trademark logo. Stylify decides to initiate legal proceedings against Trend Run for trademark infringement. Decide. Stylify can exclusively use the logo for branding purposes. Okay, registers the trademark, and then the company licenses it to Fashion Nest. Then competing house starts using the logo. Then Stylify decides to proceed against the trade against Trend Run top 3. Stylify can exclusively use the logo for branding purposes. This is correct. Stylify can license the logo to other parties for financial gain. This is also correct. Stylify can seek legal protection and pursue litigation in case of infringement. That is also correct. Stylify can prevent all businesses globally from using logos of similar kind. Now, that is also correct, right? So, but then this is registered under the national trademark law. And unless it is registered in all the jurisdictions, it will not be able to gain global protection. It will be able to gain only national protection, right? So to that extent, this doesn't seem to be correct. Globally, from using logos, this global word has a problem. Exclusively use the logo for branding purpose. This is correct. Why this is shown like this? I don't know. Can prevent all businesses globally from using logos of similar kind. Exclusively they use the logo. Stylify can license the logo. What is the problem? Why this mistake is coming? I think this question is not copied correctly by the staff. So 1 minute, let me check it out. Yes, I don't know why this is coming. This one, maybe it will go away when it is restarted. Anyway, now I have corrected it simultaneously because this is slightly important because that gave a very wrong impression. Can exclusively use logo for branding purposes that we have already seen, and they can give a franchisee also. Can license, that is giving a franchise arrangement for a royalty. Can seek legal protection, that is exactly the purpose of registering a trademark. Reserve legal protection for the property that you have acquired which is encapsulated in your trademark and which is valuable for you because it gives you access to customers because customers identify your trademark with the goods of your company and they go for purchasing the goods of certain company, and the company is there in their names only because of the promotional activities that you have undertaken, and those are encapsulated by popularizing your trademark. So this is legal protection. Stylify can prevent all businesses globally. Now that is not possible unless you register in the global system because it is a national trademark. Here it is standard, it is national trademark law. If you are nationally registered, you have a protection only limited to the national boundaries. You can't proceed beyond. If you want beyond in 130 countries, you have the Madrid system under the WIPO, World Intellectual Property Organization, which is a specialized organization of the United Nations, an independent organization just like the World Health Organization. So, and it helps in intellectual property, patents, copyrights, trademarks, and all that, right? So, this is how it gets. This is not going. I don't know why it is going, but it will go. I guess I'll ensure that it goes. Then we have question number 125. Now you see where the dishonesty comes in. The dishonesty comes in. You see this glow tech. Yes, I'll link it up a little bit so as to make it a little clearer. If I link it up like this, glow tech and just see glow tech. What are they showing? Now, easily a customer of one can confuse the other. This is perfectly possible, right? So, what do you see when you assess the trademarks, the difference in the trademarks? You don't allow Phonetic similarities, that is similar sounding words you don't allow. You don't allow the graphical similarities, that in the written form they are same. You don't allow that. You don't allow similarities between two trademarks. And how do you know whether two trademarks are similar or they are not similar? You also look at the customers, right? Now you look at the customers and see how sophisticated will be the customers, right? For example, Glow Tech and Glow Tech. So these are two trademarks. So if it becomes, one is Glow Tech and another becomes Glow Light or Glow Pure, something like that. Now there is less likelihood that merely because the word glow is common between the two, the customers are going to be misguided, because there is a verbal dissimilarity between the two trademarks, which has also created phonetic dissimilarity. They don't sound similar, right? They are not similar. There is a verbal and a graphical dissimilarity between the two trademarks. But if the audiences are not very sophisticated, if the audiences of your products are supposed to be, say, people who are illiterate or people who are less educated, who will not be able to distinguish between, say, glow tech and glow light. So then in that case, the court may say that no, these are similar. So what is the benchmark on which you decide that there should be no similarity between the two trademarks? That is, the courts look at not only the trademarks in question, but also look at who are the potential customers for the products represented by these trademarks. The courts also have that into account when they decide whether or not there is a similarity between two trademarks, right? But then here the similarity is very pronounced. Glow Tech and Glow Tech, they seem to be very similar, and therefore they are bound to be disallowed, right? Uh, there is phonetic as well as verbal dissimilarity between the two words, and hence this kind of subsequent trademark registration of Glow Tech will not be permitted or is unlikely to be permitted. Having said that, let me go to the next question. A small business, Sweet Bites Bakery, uses a signature pink and gold logo for its cakes and pastries. The business has not applied for trademark registration. A competitor begins using an identical logo. So what will happen? As I told you that if you have the registration, your your intellectual property is secure, your task becomes easy. Just have to approach the court and file a suit for registration, infringement of a registered trademark. And the court, once it is proved, once you enclose among the petition papers the trademark certificate of trademark issued by the trademark registry, the court will start taking up and will start questioning the defendant on whether, and start examining whether or not there was an infringement of the trademark, whether or not a rival business started using a similar trademark, which has phonetic similarity, that is sound similarity, which has verbal similarity, or which has graphical, or which has similarity of other means which are presently permitted, like fragrance, like sounds, like uh, smells, like the videos. All kinds of combinations are permitted. All combinations which are meaningless, which don't have any meaning. The moment the combinations start saying, or say they are commendatory of the goods that are being for which the trademark is being used, then in that case the trademark will not be registered. But then we are on a slightly different question. We are on whether whether this kind of trademark violation is possible when the trademark itself is not registered. That is to say, the trademark is not in existence. Then in that case, always remember, a civil suit for infringement of the unregistered mark can still lie, because you still have the property which you have earned by your hard earned efforts. You have acquired property. The only thing is, you will have to now proceed against the common law right. You will not be able to go under the trademark act. Because the trademark only grants registration, does not generate the property for you. The property is there. Once the property is there, it has to be protected. Whether you have the registration or you don't have the registration, it is meaningless. If you have, say, a marriage registration is there, it is only a registration. If suppose the marriage is not registered, and this question may figure sometimes, it has figured in the examinations, in the legal type of aptitude type of test. Registration is merely of the fact that the marriage took place. Registration is not does not create per se. The registration does not create the fact of marriage. Fact of marriage is independent. Even without a marriage registration certificate, you can prove that yes, the marriage took place. That does not go to affect the status of the marriage, status of the couple who are in wedlock. That does not touch upon such a status. It only certifies that yes, the certain couple came and to the registration to come for registration and were granted a registration certificate after proof of the after obtaining proof from the couple about the uh, about the solemnization of the ceremony of marriage. So try to understand that the right inheres in the property, inheres in the trademark, in the user, in the use, in the association of goods, in the goodwill that the goods have generated, in the association of the goods with the particular logo. And the logo has value in the minds of the customers, which sets the company's goods apart from the other companies or rival companies' goods. Therefore, the civil suit for infringement would still be maintainable. The only difference is now you will have to prove the user in the court that yes, you are in actual use. When you have in registration, you don't have to prove the use because the registration, while the time of registration, you have already proved the user. You don't have to. Suppose there are 10 infringements in 10 different countries. Go proving in 10 different countries or 10 different locations about the use, about your prior user. But if you have a registered trademark, you don't have to prove anything. You just start off with putting the defendant on the defensive. That is the advantage conferred by registration. It grants you exclusive right to exclusive use. You can prevent others from using. In the other one also, you have an exclusive use, but then you'll have to establish that there is a trademark in existence. Then there is a mark, not trademark. Trademark you have not applied for, so there is no trademark. There is a mark in existence which is your proprietary mark and which you have been using in the goods. And of course, it should have satisfy all the requirements. Like it should be a nonsensical word if you are using a word. Like all these words, you will notice kindly that eco blend. It doesn't make any sense. It is eco blend. You don't write like that. Eco and blend. Suppose I separate this eco and blend, then it will not be registered because then it becomes sensible. Now you please see Sweet Bites Bakery. Sweet Bites is one, right? So Sweet Bites can be registered, but if I separate sweets from bites, it won't be registered because then it will start making sense. If I'm and besides, you see, if you separate both the words will start making sense. Sweet and bites. Bites means I'm taking a morsel of food in my mouth. That is a bite. So sweet and bite, they will make sense. That the bite when I take something in my mouth, it smells good, it feels good, it tastes good, all that sweet. So sweetness is associated with it. Now this will at once become problematic. So mark will become problematic, but the registration, because of registration, the mark has already crossed that threshold. Nobody will say that look, this is not a mark at all. This is a this is a this is a word which is a commendatory word for your goods. Therefore, it cannot be registered. Likewise, if you see glow tech, it doesn't make any sense. But if you separate this glow and tech, it would probably start making sense. It would be like glowing technology. So that would immediately means glow tech means it's fantastic state of the art technology. So it will create a problem, right? Likewise, stylify. So style has been converted into stylify now. It doesn't make any sense, right? Fashion nest. So fashion nest, if I separate the words fashion nest, then it will create an immediate problem because fashion nest would then signify that there is a firm which is which goes by the label under the label style of fashion and nest. That means it's a place, a premise where fashion products are probably made or designed or sold or stored or possessed or distributed or retail or something of that kind is done, right? Likewise, trend run, it doesn't make any sense. But if I separate it, they may start making sense. The moment they start making sense, they are not a trademark. I hope the difference between a mark and a trademark is clear to you now. Because if the mark has not crossed all these hurdles, it may still be put into jeopardy. They say that this is, you are saying tasty. Now, tasty cannot be registered. Suppose you are using tasty with chocolate. Now you say it is tasty. So tasty cannot be registered because tasty is a descriptive word. Taste something which is good taste. So it is tasty. So I can say that it is an adjective. It is a descriptive word, and if it is an adjective, then you can't register it, right? So that now equivalent I already dealt with it. These questions I will not take because these are verbal. This thing. There is something else also. Company creates a unique jingle. Now these you have marked correct. These are based on the new changes which have been made. Jingle is being allowed to be registered. Then you have read it very carefully. It seems you have towards the end it is written, so you have not overstepped. But this is marked incorrect. A company discovers that another business is using its registered trademark. Company files a lawsuit to stop the infringement. What is the likely outcome? Court will enforce the trademark and stop the infringement, of course. Court will dismiss the case if the respondent shows prior user. Now, that is a registered trademark. You see, prior user concept does not apply because it is a registered trademark. You have a window period within which you can have the grant of registration cancelled. But once it is registered, then you go and challenge the registration. In that case, you follow what I'm saying. Court does not grant the registration. Then you will have to tell the court to please hold back. Let me go and challenge it before the registry that I am a prior user and that you have wrongly granted this trademark to them. So your forum will change, but here the court will act on the basis of a registered trademark. The court will grant you the liberty to do that. That is a different story. The court will allow, because this is not the court's jurisdiction to grant a trademark. This is not in the court's jurisdiction. The court implements the existing trademark, a registered trademark. For trademark registration, there is a separate registry, just like in the Madrid case. Madrid system we have seen MIPO under, which is a specialized organization of the United Nations organization. Those are the institutions which are registering the trademark. The court is not registering the trademark. The court is only entertaining infringement suits based on registered trademark. Court will not undertake this exercise because court is not competent. Court doesn't have the necessary skills for assessing a trademark application. For that, there is a separate authority. For that, the authority has specialized training and the specialized tools available to it to handle such application. Courts don't have those tools. Now, the court will allow both companies to use the trademark if both started. Now, that is not the court's job to allow or disallow a particular trademark. That is the trademark registry job. Whether to cancel a granted trademark because there was somebody else who was doing a prior user of that trademark in association with the goods that are subject matter of this petition. The court will require the company to share the trademark for concurrent user. The court will have, as I already explained. All right, come to passage number 16. I hope the trademark concept is absolutely clear to you. You will not make a mistake when the question figures in the examination, and you will score out because of the, without referring to the Trademark Act, we have acquired some understanding of this. Because Trademark Act, nobody will ask you what is the Trademark Act providing. That you will do in the law school. That you will not do today. Today you will do all based on what is appearing in nyai.org or in other literary articles, how they are appearing in other places. So those are the ones which are relevant presently. I'm sure you'll agree with me when I say that, because you'll never see, rarely they reproduce sections and all that. They'll put FAQs, they will produce newspaper articles, they will produce small write-ups, all those, and then try to assess your legal acumen based on the information supplied to you, your capacity to reason, which all of them which can be sharpened by practice. And this is exactly what we aim to do. Now, having said that, please come to this uh, passage number 16, mock 63. Quickly go through the passage. If you have already go through it, you can start telling me straight away. If you want some time, 2 minutes, 3 minutes, 4 minutes. Even if I shut down the video or the audio, it doesn't mean I am away. I am just nearby. In order to avoid some distraction, I shut it down. But I am around. You can keep speaking if you are there with it. While the camera, while the class is going on, I will not go far from this thing, right? So
Passage talks about
yes,
a
please.
case where a wife is entitled to half of her husband's income for child maintenance, regardless of her earning capacity, and both parents shares equal responsibility for raising the child. And where the husband argued that his wife was MA qualified and she is capable supporting herself, but court rejected his play and starting that child rearing is a shared duty. And under the Section 25 of Hindu Marriage Act 1955 talks about the alimony and maintenance. The court can order maintenance for uh, court can order maintenance for either spouses based on income, property, and the other circumstances. Payment can be modified if circumstan- circumstances change, and the maintenance can be revoked if the recipient remarries, is unchaste, or has extramarital.
So this passage talk about a recent ruling of Jodhpur High Court, Jodhpur Family Court. So in this case, a family court in Jodhpur said that even if a wife is educated and can earn, she still has the right to get money from her husband to help raise their child. And in this case, the court asked the husband to pay rupees 15,000 per month for their son's care, and the judge said that both parents are equally responsible for the child's upbringing. And the wife, Miki Chauhan, she had told the court that her husband, Rajnish Chauhan, started troubling her after marriage, and he also forced her out of the house. And she had been living with her parents and raising their son alone since 2013. And the husband said that well educated, and she is already getting rupees 3,200 per month from him through a past court order. And uh, so that's why he said that the case should be rejected. And but the judge did not agree with him. And the court said that the wife deserves support for the child no matter her qualifications. And this decision is in line with the section 25 of the Hindu Marriage Act, which allows the court to give financial help, alimony to a husband or wife after marriage. And this all depending on their needs and income. That's all from my side.
So recently, a Jodhpur family court had laid down a judgment that that both parents are equally responsible for the financial upbringing of their children, regardless of the earning capacity of either one. So this is in regards to a divorce case between Miki Chauhan and Rajesh Chauhan. So Rajesh Chauhan was a medical representative who had multiple streams of income. And what happened is that after their marriage, Mickey used to get harassed by her husband, and this continued for a few years until she was expelled from the house. Afterwards, she had been living with her parents with her young son. So in 2014, Mickey had filed a maintenance case in the family court in Jodhpur for financial support for their son. She had claimed that even though her husband had used to earn more, he was refusing to pay any proper alimony or child maintenance. However, had opposed this petition. He had argued that even the Mickey was well educated and was capable of earning and supporting both herself and the child, and that he was already paying 3,200 rupees per month. In a previous domestic violence case, and had said that the current petition should be dismissed. So the court had ruled that even though both of them are capable of earning and the husband is earning more than the wife, both of them should have the responsibility to pay for the upbringing of their child. So the court then ordered Rajesh to pay 15,000 per month as maintenance. So this ruling was based on Section 25 of the Hindu Marriage Act, which allowed the spouse to seek alimony or maintenance from each other. Now, the significance of this judgment is that it made clear that child support cannot be denied because the guardian in question is qualified of or capable of earning. Both of them must pay, and that a child is a shared financial duty, and education or earning potential does not absolve either parent. That's all from my side.
So this is an article on family law and Hindu law in particular, and you have summarized it very well. That the lady was um, um, not supported financially, and she also underwent trauma because of violence, and she started living separately, and the court ordered for her maintenance, and she asked for maintenance based on the requirement for supporting her child. Both the parents have the responsibility to support a child. It is not only the wife, or it is not only solely the husband who has the duty to support the child. Both of them share the duty to support the child born out of the wedlock. Now, if we have a look at the provisions a little closely, which are actually quoted in the fact situation itself, many of the things will become clearer. It says Section 25 of the Hindu Marriage Act. What does it say? It says any court exercising jurisdiction may at any time of passing any decree or any time subsequent thereto. So this constitutes a marked it incorrect. They have said, or should I take up the questions first and then exemplify by reference to this? Because I think I should take the questions first. There's nothing much in the facts of the summary as such. You have a duty to maintain your spouse, you have a duty to maintain your children, you have a duty to maintain your dependent parents. So this is the law under the Hindu law. Now, how it applies, that will be brought forth in the practical situations which are there in front of us in terms of the questions. So let us go to the questions first, I think. Then it will become a little clearer. Now this is already marked correct, 100%. So I will not take it up. Maintenance includes shelter, education. You already know all that. So I will just point out which provision of the law provides for all that. I will just refer to that. It says, uh, I think here it is, that court exercising jurisdiction at any time passing any decree or at any time subsequent thereto, an application made to it by either wife or the husband, as the case may be, order that the respondent shall pay to the applicant for her or his maintenance and support. So the concept of maintenance and support would include not merely the maintenance and support by way of monetary entitlement, monetary provisioning, but also maintenance and support by shelter, education for the child, and all that. So those gamut of rights are also included in this, and the courts have given a liberal interpretation to maintenance and support, and they have not confined this maintenance and support merely to financial maintenance and support. So I will just clarify because you have already marked it correct, so I will not spend much time on it. Now it is 134. 134 is correct, so I need not go on that. 135, husband is out of employment. So if the husband is out of employment, then the wife is financially stable. The husband is also um, um, can the husband claim maintenance? Yes, he can. If the husband can claim maintenance, where is it written? This is where it is written. If you kindly have a look at this, um, here it is. Here it is written, and uh, at any time decree or at any time subsequent to on an application made to it for the purpose either the wife or the husband. So the application may be laid before the court either by the wife or the husband, either of them. So this is very clear that it can be either the wife or it can be either the husband, right? They can claim maintenance from each other. So this I have clarified by reference to the this thing. Then 135 kids are marked in incorrect. So let me take it up. A woman who has been living separately from her husband due to cruelty files for maintenance from her husband. During the pendency of the proceedings, the husband passes away. The court dismisses the application for maintenance for becoming infructuous due to death of spouse. The woman appeals against the verdict, decide the appeal. So how will you decide the appeal? The husband has passed away. Does her right to maintenance go away? No, it doesn't. Who who is liable? The legal heirs of the husband are liable. And who are the legal heirs? Whoever are the legal heirs of the husband. Say his son or say son of both of them or the in-laws. All those will become the legal heirs and they will become liable. Where is it written in the law? Here it is that it is written in the law that at the time of passing any decree or any time subsequent thereto, right? At the time of passing any decree or even after passing the decree, right? Then may order shall pay to the applicant for her or his maintenance support. So when the application is laid, then no time is specified. Suppose divorce is granted, thereafter also the maintenance application can lie. While the proceedings are going on, at that time also it can be decided. At any time of passing of the decree or any time subsequent thereto, subsequently also the decree can come, right? So this is clarified like this. And here when the husband passes away, then it can be any time after the decree, before the decree, any time you can come and claim maintenance. That is your legal right. So it is not constrained in any manner. Now please come to 136. Wife who is a dentist files maintenance from husband. This we have already covered. The husband objects she is capable of earning livelihood and willing earning more. The wife contends that despite her professional income is insufficient, still the wife can claim maintenance. Right? If the income is insufficient, the wife can claim maintenance. Where is it written? Where is it written in the passage? Here it is. Shall pay to the applicant for maintenance and support. So maintenance and support means adequate maintenance and support. If the own resources are not enough, so I read further. Having regard to respondents' own income and property, if any, the income of and other property of the applicant, the conduct of the parties and other. So it is a composite decision which is arrived at. It is a holistic decision by taking all facts and circumstances into account. The court arrives at a decision in that the respondent's own income, the the income of the income of the applicant and all those considerations are taken into consideration. And if it appears to the court that yes, the income of the applicant is not really sufficient to maintain herself, the court can order the maintenance, right? Then I go further, and that is I go further. Yeah, so this is interim and all that. We not spend time on this. So one question I think which I overlooked in the foregoing this thing. I don't know whether I overlooked a question. Um, this I have done. This is also done. Yes. Now this is 138. A woman receiving maintenance from her husband under 18, over time her medical expenses increase significantly due to chronic illness, approaches the court to request increase in maintenance amount. She can do that. Subsequently, the order can be modified. You have already seen that in the Fed situation. Uh, uh, you have already seen that. So the order can be modified also. As the case, it may seem to the court to be just. Any such payment may be secured if necessary by a charge on the having regard to this. If the court is satisfied that there is change in the circumstance of either. I'm going for sometimes Dadiya video, but court company उससे उसको बड़ी का पैक भी खाजा नर्सरी के बच्चे के लिए थोड़ा सा देखते के लिए मैं मान सकती हूँ फाइनल उसको दीनदयाल को फोन किया था कि यार आ जाओ कंपनी में चलेंगे थोड़ा तो बोला आज तो मुझे टाइम नहीं है. They say if the court is satisfied that there is a change in circumstance of either party at any time after the order, it may, at the instance of either party, vary or modify, resign the order. So you see, the order once made is not final for all times to come. If there is a change in circumstances, then the order can be modified also. If suppose wife finds herself in placed into a large amount of funds and the position of the husband changes in an adverse way, so the order of maintenance can be set aside also, and instead the wife can be made to pay the maintenance to the husband. Right, to that extent, the now files counter petition to reduce the maintenance. Now, having said that, let me go to the other aspects of this. Meanwhile, her husband files a um, meanwhile her husband files a counter petition to reduce the maintenance, claiming that the woman has started earning an additional income. Additionally, the woman later converts to another religion, and the husband requests the court to cancel the maintenance altogether. So, whether it can be done? What is the law saying? Whether it can be done? Please come to this part. If the court is satisfied that the party in whose favor an order has been made under this section has remarried, or if such party is the wife, that she has not remained chaste, or if such party is the husband, that he has had sexual intercourse with any woman outside the wedlock, it may, at the instance of the other party, vary and modify, resign any order. So you see, if now the fact situation says that if you have additionally woman converts to another religion, that is another fact. So if the woman converts to another religion, then whether the maintenance order would apply? The answer is no. Why the answer is no? Because what does the Hindu title is Hindu Marriage Act. So, or who does the Hindu Marriage Act have the jurisdiction? The Hindu Marriage Act has the jurisdiction over who? Or Hindus. Just to clarify the matter a little bit further, I'll just share it with you. So it is not required to be shared because it's a matter of common sense. I'll take you to the short title and extent of the act. Act may be called Hindu Marriage Act. So the name is Hindu Marriage Act. Means it applies to Hindus. The name itself shows. Extends to the whole of India, state of Jammu and Kashmir. That's okay. That's all gone. Applies to Hindus. And if one of the parties ceases to be a Hindu, it will not apply. Suppose one party becomes a Buddhist, or if one party, but then the act says that Buddhists are also Hindus, so it will continue to apply. But somebody, suppose, becomes a Christian, or becomes a Zoroastrian, or becomes, say, a Muslim, or becomes, becomes something else, to which the act does not apply. In that case, the court has no jurisdiction to thereafter entertain the application, because this law applies to Hindus only. It does not apply to members of the other faith. The moment you cease to be a Hindu, then the act will not provide the jurisdiction to the court to continue to entertain the application, and the application will be dismissed. Having said that, let me go further.
So what if a person becomes atheist?
Hinduism permits atheism also. Theistic
Yes,
and
but,
atheistic.
what would you classify as modern atheism, or in the Hindu sense of atheism, like following your traditions but doing worship? So
That
how
depends.
are you classified in this?
Huh? What will you say? Come once again.
So We know modern atheism that rejects basically all notions of religion and traditions, and then there's the Hindu atheist idea where you follow traditions, you follow the scriptures, but you do not follow the worship that is there. So, how do you define atheism in that sense in terms of this law? Because that would get really confusing, no?
Look, that will require us to explore the concept of Hinduism in a slightly greater detail as to what is included in Hinduism, what is not included in Hinduism, what the act provides, how the act envisages a Hindu. I'll just refer to it because that's an interesting question that you have posed. So I'll just take you to who is a Hindu. So whether a atheist, whether a theist, whether modern atheist, whether primitive or pre-modern or post-modern atheist, who is a Hindu? So it will not clarify in such depth, but nevertheless, the expression Hindu is clarified in the act, and the Hindu is clarified in this section. Just give me a moment. Let me fish it out for you. Um, just 1 minute. Yes. This is section 2, application of the act. Please come to the explanation here. The following persons are Hindus, Buddhists, Jains, or Sikhs by religion, as the case may be. Right? So, the act will apply to Hindus, to Buddhists, to Jains, to Sikhs. All these, they all are constituted to be Hindus only. That is why Hindu Marriage Act applies to all them. Right? And now, to who does it apply? Any child, legitimate, Buddhist, Jain, Sikh, and all that is there. It partly answers your question. If the theistic tradition, if a theistic postmodern tradition or a modern tradition, postmodernism and modernism are two different philosophical strands. Now, Hindu and Buddhist and Jains and Sikhs, if you fall in any of these, then it is covered. But if it is not covered, if it is does not fall in any of these, then we have to consider as to what is the concept of Hinduism, whether we can assimilate by analogical extension of the concepts, whether we are. That is where everything goes for a spin. The moment you start applying the law, it takes a very creative kind of a separate kind of creativity. It is not just that these are a few sections and that's all. No, the people in law you debate on whether you are a man, who is a man, who is a woman. For example, the UK Supreme Court has given a judgment on 16th April. This 16th April, 16th April. They are saying who is a woman, whether a transgender man is a woman. So I have included that in one of your these mocks. Very interesting this thing. So it's a very creative kind of disputation. Legal disputations can become very creative. Anyway, let me move forward. I hope I have answered your question partly. Let us go to. I think we have taken up a new this thing. We have exhausted all that. Yes, we have exhausted. We have come to a new new passage. This is this thing. Can we take it up tomorrow? Because we have missed one of the classes. On Monday we missed the class. So take up a compensatory class tomorrow. So will you be available if we take it up tomorrow? Only 2 questions are left. But then 2 questions, if we do them properly, they take time. You just can't go through them. You just explain and then that doesn't happen. Okay. Are you happy with that? Because in any case, we have missed one class. On Monday, we missed the class. When I was in Delhi, I was not here. I was out of station. So let us take that up tomorrow. Slowly, if we can do it.
Okay, sir.
All right. Now, what I will do is the trademark concept had certain videos into it. I'll put the video file into this so that you just remember your remembrance because your recall becomes better. So I'll just put the link in the form. So just to make you recall better, right? And I'll also include the concepts of WIPO, Madrid system, and all that in one of the answers to the question, in the explanations, in the feedback they call it. So in the feedback. So to that extent, I think. All right then. See you tomorrow. What time are you available tomorrow? Tomorrow is a Sunday. We can make it up in the morning also. No problem. Or whichever, if you want to keep the same time, it can. It is better to keep it in the morning, because then daytime is available to you. There are so many tasks that have to be done on Sunday, and all those tasks are consigned to the basket of Sunday, because on other tasks you have a class to take, you have a paper to make, you have so many readings to go through, you have selections, so many things have to be done. It is like making a paper every day, that kind of thing, which is also a very enjoyable exercise. I mean, it is an intellectually very, very productive kind of exercise. So let us keep it up early tomorrow morning at 7 a.m. Is that okay?
Yes, sir.
Yes, sir.
What about you, Priyanka?
Okay, sir.
All right, Vital, let us keep it at 7 o'clock sharp. And it won't be long. It will be around 45 minutes to 1 hour. That's okay. Bye bye.